Case brought in the Chancery Court for the Knox County, Tennessee, Part 3. Kenneth John Pachinger versus William Lee, Governor of the State of Tennessee in his official capacity, and David Rausch, Director of the Tennessee Bureau of Investigation in his official capacity as defendants. Present in this three-judge panel are Judges Gay, Addison, and myself, Chancellor Christopher Haggerty. Could all counsel or could counsel make himself known for the record, please?
Hello, Your Honor. This is David Wickenheiser. I represent the defendant in this case.
And thank you, Mr. Wickenheiser. And is the plaintiff here?
Yes, Your Honor.
All right. And Mr.
That's
Pachinger?
me, Kenneth Pachinger.
All right.
Yes, sir.
Okay. All parties are here. Today's hearing is centered upon a motion to dismiss that is filed by defendants Lee and Rausch, I believe, and the response thereto, and the reply filed to the response by the defendants. At this time, since the movement has the burden, the movement will argue first. Are you ready, Mr. Wickenheimer?
Yes, sir.
All right, if you would go ahead, thank you. There'll be no limitation on your argument either.
Thank you, sir.
Question, Chancellor, is the defendant on Zoom? I haven't seen him.
Well, the plaintiff's on Zoom.
Excuse me, plaintiff. Excuse me. Is the plaintiff on Zoom? I don't have him showing on my.
He's showing on mine.
Okay, that's fine. Just want to be sure he's included. Go ahead.
All right.
Yes, sir.
And
Thank you.
we are assuming that the individual Ken, you've not included your last name on your device. Thank you.
Yeah.
For the purposes of the record, Mr. Pachinger has identified himself just a few minutes ago, and he is in attendance. If the state would go forward.
Thank you, Your Honors. My name is David Wickenheiser. I represent the defendant in this case, and thank you for having me here today. The panel should dismiss this case for two reasons. First, Director Rausch is not a proper defendant. And second, even if he was, plaintiff has failed to state a claim that would entitle him to relief. Turning first to the issue of whether Director Rausch is a proper defendant, the complaint makes no allegations that reflect any allegedly unconstitutional actions taken by Director Rausch. Indeed, the complaint only contains the following allegations of allegedly unconstitutional conduct. On page 5 of the second amended complaint, plaintiff alleges for 2 pages that Tennessee's geographic exclusion zones and in-person reporting requirements are unconstitutional. Then on pages 7 and 8 of the second amended complaint, plaintiff complains that he was categorized without an individualized assessment. Going through these one at a time, Director Rausch simply does not enforce the geographic exclusion zones or the in-person reporting requirements. Instead, Director Rausch has a merely administrative role, which includes designing, printing, and distributing forms, maintaining the SOR database, and maintaining an internet connection for the registry so that local law enforcement can enter accurate data, among other administrative roles. Indeed, the Sixth Circuit evaluated the issue of geographic restrictions already and found that those restrictions are, quote, enforced by a diffusion of state officers and prosecutors, which are not parties here, end quote. That's from Doe v. Lee case, which is found at volume 104 of the Fourth Federal Reporter at page 341. Indeed, the Sixth Circuit concluded that, quote, Director Rausch cannot be enjoined from enforcing provisions of the act which he does not enforce. That is the case here. Plaintiff's specific complaints about geographic exclusion zones and in-person reporting requirements cannot state a claim against Director Rausch because he is not the person that enforces them. Moving on to the allegation that TBI categorized plaintiff without an individualized assessment, it is the SOR framework itself, not the TBI, that requires individuals to be classified as a violent offender or sexual offender without an individualized assessment. Indeed, plaintiff does not dispute that he's required under state law to register as a violent sexual offender or comply with the geographic exclusions because of his status as a violent sexual offender. Director Rausch merely publishes facts that are defined by state law. As a result, any offender is subject to arrest and prosecution by local law enforcement and local prosecutors for failing to comply with the SOR framework because the obligation to register and comply with those exclusion zones and reporting requirements is created by operation of law, not upon classification by the TBI. And in any event, plaintiff, in his response, did not attempt to grapple with Director Rausch's point that any sex offender registry framework would necessarily need to classify individuals and has never been considered constitutionally suspect. Indeed, the United States Supreme Court approved a framework that classified individuals based on the type of offense they committed, and that was in the Smith v. Doe case. Director Rausch's role in classifying and not enforcing any allegedly punitive restrictions is insufficient to state a claim and certainly not enough to state an ex post facto claim. Moving to the second basis for dismissal, even if Director Rausch is a proper defendant, the complaint fails to plausibly allege facts that would entitle plaintiff to relief. Turning first to the ex post facto claims, to state an ex post facto claim, a complaint must show a regulation is both punitive and retroactive. But as described above, the only allegedly unconstitutional activity identified in the complaint carried out by Director Rausch is the classification system. But a simple classification system without enforcement of actual SOR obligations or restrictions is simply not punitive. So the complaint does not state a claim against Director Rausch. Classification on its own bears no resemblance to the Mendoza-Martinez factors used when establishing whether a regulation is punitive. Mere classification has never been regarded in our history and tradition as being a punishment. Classification on its own without any of the obligations under the framework bears no affirmative disability or restraint. The classification promotes the avoidance of future harm to the public instead of the traditional aims of punishment, which are retribution and deterrence. Informing members of the public of offenders' previous crimes is rationally related to the non-punitive purpose of protecting the public. And finally, simple classification of individuals into a category of sex offender or violent sex offender is not excessive compared to the public benefit of informing the public of offender locations and preventing them from going into protected areas like schools or parks. And in any event, even if the panel wanted to avoid the issue of whether Director Rausch's role could be considered punitive, the law itself is not retroactive. It does not seek to address past conduct. Instead, it seeks to prevent future conduct. The law looks at antecedent facts, which would be the offender's previous conviction, and then imposes a regulatory scheme for that set of individuals that then have to meet those requirements. The defining characteristic here is that the law does not create liability for past acts. Instead, the SOR framework is designed to address post-enactment future dangers. Numerous federal courts have addressed this issue head-on and have determined that SOR frameworks are not retroactive, and that extensive list of cases is contained in our memorandum of law. As a result, the complaint has failed to state an ex post facto claim against Director Rausch. Turning next to the complaint's religious liberty and voting rights claims. Those claims fail for the same reason. The complaint has not alleged that the TBI or Director Rausch plays any role in enforcing the geographic restrictions he is complaining about. As explained earlier, the geographic restrictions prevent the plaintiff from the geographic restrictions are what prevent the plaintiff from being able to potentially attend church or go to voting locations. But those are enforced by a diffusion of local law enforcement and prosecutors. Director Rausch and the TBI do not enforce those geographic restrictions. The plaintiff has not stated a claim against Director Rausch, and the court would not be able to enjoin Director Rausch from enforcing the geographic restrictions because he does not enforce them. And in any event, the SOR framework is a neutral policy that is generally applicable to all individuals on the sex offender registry, regardless of religious affiliation. As a result, even if Director Rausch were a proper defendant, the complaint has not stated a First Amendment violation under existing First Amendment jurisprudence. Similarly, the voting rights claim simply does not address that plaintiff has numerous avenues to vote, including early voting or requesting to vote at a different location. As a result, the complaint fails to plausibly allege facts that would entitle him to relief. Finally, addressing the due process claim, as we've already explained above, offenders are classified by operation of law. As a result, no relief would be available to this claim because Director Rausch is required by law to classify individuals and in the enumerated way that the framework requires him to classify. And the Supreme Court case, Connecticut Department of Public Safety versus Doe, is dispositive of this issue. It held that due process does not attach if a petitioner would only be able to prove facts that are not material in the state statutory scheme. The complaint has not alleged any facts that he would like to prove, that the plaintiff would like to prove, that would change his classification. Instead, the complaint alleges that plaintiff's classification does not take into account his current level of dangerousness. However, the SOR framework does not even permit Director Rausch to consider that fact when taking into account his classification. As a result, there are no facts that plaintiff would be able to show in a due process hearing that would change his classification under Tennessee's SOR framework. So due process does not attach to that issue. The panel should dismiss this case because Director Rausch is an inappropriate defendant, and because the complaint has failed to plausibly allege facts that would entitle the plaintiff to relief. Thank you for your time, Your Honors.
Let me ask you a question before we switch
Yes, sir.
to the plaintiff. You're telling me that we can dismiss this one just for the single reason that the director is not the proper party defendant, and we don't have to even deal with the other issues based upon your contention that the enforcement of these laws are not done by the director himself, but through a diffuse. How did you say it's a diffuse?
Collection of law enforcement and prosecutors.
So you're sheriff,
Yes.
sheriff, police officers, many others, and even election officers, probably, I would think. Is there any reason for us to reach that far into this argument, or just for the purposes of judicial economy, it's your contention we could dismiss it just on that one issue alone?
Yes, sir. I think that if you all agreed that that Director Rausch wasn't the proper defendant, I think for judicial economy and for not dealing with tricky constitutional issues, I would think that would be the most appropriate avenue.
Well, the way you couched it though previously is they weren't so tricky when you were talking about them the first time. You cited at least 3 cases you said were dispositive of 3 of the 4 issues. What's the 4th issue that there's not a dispositive case on? Or is there a dispositive case on each of the issues?
Yes, sir. I mean, I think we would prevail on the merits if we did get to the merits of the actual constitutional claims. But my personal opinion would be it would save the court time, and I think it would also just be efficient for everyone.
So under no set of facts, under Rule 12.026, is the director a proper party here?
Yes, sir.
All right, thank you. Does anybody else have any questions before I allow the plaintiff to respond?
I've got a couple. This is Judge Gay. What standard are you using to apply standing?
Yes, sir. I think we've really articulated a 12B6 standard or 12.026 standard, Your Honor, but I think a 12.021 standard would also be appropriate. I think the way I read the motion to dismiss was a 12.026. But
have you looked at Memphis versus Hargett? And they've got three principles there, and I'm wondering what principle of law, and maybe I didn't catch it all, but what principle are we looking at? What standard are we looking at, and why are we not looking at Memphis versus Hargett?
So, Your Honor, the motion to dismiss, I think, was written as it really wasn't written in the context of standing. It was really written in the context of failure to state a claim because there would be no relief available given that Director Rausch doesn't actually enforce the statute. And so I think
Yeah,
that
but you're raising it.
so I think the 12.026 standard that there's just no, he hasn't stated, the plaintiff hasn't stated a claim because this is the wrong defendant. I do think that is an avenue, but I do think you're right. We probably could have done more analysis. And I'm not familiar, Your Honor, I'm not, to answer your question succinctly, I'm not familiar with the case.
Okay,
And I could
okay.
certainly, if the court would appreciate it, we can provide briefing on that. But I'll confess I'm not familiar with it enough to answer the question.
Well, let me tell you something. I've been a criminal court judge here for 19 years, and I've handled a lot of these cases. And what we're talking about, if you apply the federal case of Doe versus Lee, we're looking at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 municipalities in Knoxville. So who is the defendant? I mean, so the plaintiff supposed to sue?
Sir, I think he could sue the local district attorney or sheriff, and that there might be a few individuals he could sue. But our position is that an injunction against Director Rausch wouldn't provide him for any relief because Director Rausch doesn't enforce these statutes.
Okay. I've got another question for you. I have looked at 4039-207, and I believe that was passed in 2024. Does that statute not apply in this case?
Off the top of Your Honor, is that the statute that allowed for
It
classification?
talks about the director as being responsible for getting the letter and then responding to the letter to terminate. It talks about the appeal going to Chancery Court, and it talks about the Chancery Court getting all the documentation that was provided.
Certainly, I think that provision.
Go ahead. Go ahead.
Certainly, I think that provision would have a lot of interplay with plaintiff's due process claim. I think that would resolve that particular statute, I think, does resolve most of his due process concerns because he, of course, can request termination and then appeal that determination.
Okay, hold on. Let me go over some of the sections with you there on 207. It kind of puts things in perspective here. Just a second. I'm sorry. Give me just a minute here.
No problem, Your Honor.
And Judge, to be sure, you're saying 4039-207?
Yes, and I've got it right here. A1 says the offender is required to register under this part and may file a request for termination of registration with TBI headquarters in Nashville. And then it goes on to say that the TBI shall review documentation provided by the offender and contained in the offender's file and the SOR to determine whether the offender has complied with this part. And then it goes on to say that the TBI shall remove the offender's name from SOR and notify the offender that the offender is no longer required to comply. And then it goes on to say that anyone that's been denied by a TBI official may petition the Chancery Court. And the review shall be on the record used by the TBI official to deny the request. You don't think that gives a defendant standing?
Your Honor, I think certainly that would address, as I mentioned, I do think that would address the due process concerns. But I think generally that deals with removal from the registry and being on that public facing registry. I think by operation of law, though, if he meets the statutory definition of what a sex offender is or a violent sex offender is, that's what creates the obligations that he cannot be within specific geographic restriction areas or cannot be or has to register.
Well,
So
I'm sorry, I don't understand. If the TBI is removing him or not removing him, isn't that a causal connection under Memphis versus Hargett?
certainly, sir, if we wanted I guess my position, I think our position is that um, because because offenders have to register by operation of law, not by TBI's classification of them, that is an insufficient connection. If the court were to find that that wasn't the case, then I think the case should still ought to be dismissed on the merits portion of the briefing, which was the second portion of my speech.
Okay, and I've got that. Now, what is the standard that you're using on the retroactive application? Are you which case are you using for that standard?
The retroactive application.
Yes,
Um,
that it's not punitive. What standard are you using there?
So there's two different tests, Your Honor. So whether or not something is punitive, that's going to be the Mendoza-Martinez factors.
Okay, are there no cases in Tennessee that we need to look at? There are two cases, Ward versus State and Bush versus State, and they deal with post-conviction relief issues. And Bush was a case where I was overturned, but Justice the Supreme Court justice that wrote the opinion went into pretty much detail about punitive and non-punitive. So were we using the Mendoza case?
So I think the Mendoza-Martinez factors, it's from the United States Supreme Court. I believe that I would have to check. I know I'm a bit familiar with the Ward case, but I haven't read it in quite some time. I believe that that's the same standard that's being used. It's just the Supreme Court kind of went through some factors to determine whether or not something is punitive.
Okay. All right. Excuse me. That was another judge from behind. Let me get into a situation that I'm a little bit concerned with, having gone through these issues in the trial court level. Let's assume that we decide the defendant has standing, and we get into the issues of ex post facto law. Is there a due process issue of a guilty plea that is entered when the defendant has no knowledge whatsoever that he's going to have to go on life supervision? It seems to me that that's a pretty important factor. Is that something that can be considered? Did the defendant raise that issue in his pleading?
I know that I think our motion to dismiss has not briefed that issue. I was under the impression that the Ward case had addressed that issue. I could very well be wrong about that. But I'm not familiar with that.
I think the Ward case addresses whether or not the registration is it doesn't apply to the application. But I need to probably look at that a little bit more. But
Yes.
do you think that's a possibility based on the pleadings of this case?
I did not read the complaint to contain that. Our motion to dismiss certainly didn't address that issue. But I do think that the Ward case would at least, I mean, I think that the Ward case says that that presence on the registry is a collateral, is collateral of the conviction. So I don't think that there would be a due process issue there, Your Honor.
Even if Ward and Bush are post-conviction relief petitions?
Certainly, they're not in the context I'd prefer them to be in, Your Honor. But yes, Your Honor. I mean, I think they would at least be influential. I don't think they're dispositive. You're correct. They're not directly on point, but I do think they're influential.
Okay. Thank you. I appreciate your patience with me. Chancellor, I'm finished asking questions.
Okay, Judge Atkins, did you have any questions?
Judge Addison here, no.
Addison, excuse me.
No, you're fine. I just think that Judge Gay covered everything that I wanted to bring up.
All right, now, since we've grilled the state a little bit, I'm gonna allow the plaintiff to argue now in response to this motion to dismiss. And looking at the brief in support of motion to dismiss and the table of authorities, there's no reference to any portion of the rules of civil procedure in here. Wonder what portion of 12.02 we're seeking relief, the state is seeking relief. So there could be a difference of how we analyze this, but let's go ahead and move forward. Mr. Pachinger?
Yes, Judge. I'm here.
It's time for your response.
First, right off the bat, I want to point out that I did raise the due process violation concerning my plea agreement. So that was part of the brief. Because I didn't know anything. I was never told anything about the registry. It was applied retroactive to me. I think Eric Holder did it in 2006. And I was notified when I left prison that I had to comply. So I didn't know anything about it. But the Sixth Circuit in Doe versus Lee relied on Snyder and it held that a regulatory regime that severely restricts where people live, work, and loiter, that categorizes them into tiers ostensibly corresponding to present dangerousness without individualized assessment thereof, was something much more troubling than Alaska's first generation. Several courts have found the classification to be a violation of ex post facto and the geographic portion of the 1,000-foot rule. In fact, Doe versus Lee, which everybody I'm assuming is familiar with, 1 through 9. On remand, the district court went through each of the arguments that Mr. Wickenhauser just made and explained why, with respect to the classification, because it violated the ex post facto, he said that by enjoining Rausch from making and enforcing such classifications under, I guess it's TN code, 4039-218, and ordering him instead to exercise a duty in a way that does not violate plaintiff's right by classifying them simply as sexual offenders and removing the violent from that classification. I know it's a statutory obligation that he does it, but this court found that it's unconstitutional, and you can't enforce an unconstitutional provision of any statute if it's found unconstitutional. This is the district court on remand from the Sixth Circuit after Doe versus Lee. And if you want that, I've got case number 321 CB 00590, and it lists several others. But other courts have found state defendants who have some direct connection with enforcing statutory schemes or some scintilla of responsibility relating to enforcement fall within the ex parte Young exception. And here the director has a clear connection to enforcement, the court said. Essentially what he gets to eventually is that the director collects the information, disseminates that information to law enforcement in the case of a violation, and then the law is enforced. He directly communicates with the state attorney and would notify him if I had violated the registry, resulting in my arrest. So the director can argue that it has no connection with enforcement is beyond me. I mean, really, I don't really have much else to say. It's just that I mean, the courts have already done it in the Eastern District. In George Million versus the director Rausch, he found Director Rausch also liable. And in that case, that was case number 322 CV 453. And in court after court, more that I read, the court finding the 1,000-foot rule and the classification system, the way it is done or enforced or whichever, is unconstitutional. It basically comes down to that. I also found in the Million case that the legislature, the Tennessee legislature, on March 25th, 2025, changed the law and now allows TBI to rely on investigative reports and things of that nature to classify someone. So I'm not even sure if that classification, if that statute is still valid, requiring him to classify people based on the statute. I don't know. I don't have access to Lexis or anything like that. I just have basic internet. I guess that's really all I've got to say is the courts make out a better argument than me. The other courts that have done this, like I said, in George Million versus David Rausch, case number 322 CV 453, the remand back to the district court, 321 CV 0059, that was John Doe 1 through 9. Verse William Lee and the director also. We've stipulated that Governor Lee is no longer a defendant in this case a while back. And the court in Doe's 1 through 9 was required to, on remand, to modify the injunction and narrowly tailor it. And he explains in great detail why he enjoined Director Rausch from enforcing those provisions against the plaintiffs in that case. And again, I mean, I could read the reasoning to you, but I don't know if that would be expedient or not. Generally, the connection with law enforcement is his dissemination of information to law enforcement, and that's part of the law enforcement.
Okay. Do you wish to address any of the other issues other than just his status as a proper party?
Yeah, that was already addressed in the cases that I just cited. You said no, go ahead.
So you're talking about 321 CV 00059, 323 CV 453. Is that correct?
Yeah, 590. Yeah.
590. Thank you.
Judge, I heard that as well, 321 CV 0059. Is he now updating the record to say 509 instead?
No, he said
00590.
590, thank you. Also, while we're here getting information, you referenced George Million. Will you please spell that out for me?
Yeah, George, and million, like $1 million, Million.
Thank you. You are a bit choppy on your end, so I am missing all of the comments that you're making. So forgive me for delaying. Go ahead, please.
I'm sorry, my internet connection isn't that great. But yeah, the judge goes through and he holds Director Rausch responsible for disseminating information to prosecutors and law enforcement and facilitate other agencies' entry of new data into the soil are all functional that fall squarely within a legitimate scheme. But other courts have found, he lists a couple other cases, and they're from the Eighth Circuit is one, and DeWine in the Sixth Circuit, and he discusses them and why they found that person to be responsible, right?
So, Mr. Pachinger, the reason I'm asking this question, the state has told us they have insisted or are arguing that we can dismiss this case just on one reason and one reason alone, that being his status as but the state's made four other arguments as they relate to the constitutionality of the statute itself. Do you wish to address those arguments at this time, or are you relying on the two cases that you've given us? Because I haven't read either one of the district court cases that you've referenced. Did they speak to the other reasons that the state is asking for this case to be dismissed? I'm having a hard time with my audio with him.
I'm sorry, I was muted. My dog's trying to go out, so he's whining over here. Yeah, they address one of those issues one after the other. No,
But you do not wish to argue those today. You just want us to refer to the case law when making our decision.
I would say so. I'm not intelligent enough to sit here and argue those. I can only repeat what the court said in those cases. As far as arguing whether or not a statute is constitutional, again, I can only repeat what other courts have stated.
Okay.
And I've given you both of the cases that I'm relying on, of course, and Dover Sleeve, of course, also.
Okay. Well,
1 through 9.
Well,
Those 1 through 9.
well, does that conclude your argument at this time? Because I'm going to give the state a chance to reply.
Yes, I would include Snyder 834 F3D 696 2016 Sixth Circuit 2016.
Okay, but does that conclude your response?
Yes, sir.
Okay, I'm going to allow the state to reply since it's their motion. Give them the last bite at the apple.
Sir, do you mind if I just let my dog out right quick so he stops?
Well, I would rather you let him out than something else happen.
Okay, thank you, sir. Pastor. Sorry about that.
Okay. Now, I want to get your answer on the record. Is your argument complete? Mr. Pachinger?
Again, I would just refer the court to those cases. The court argued it better than I ever could.
Okay, so I'll take that as a yes.
Okay.
I'm going to allow Mr. Wickenheiser a chance to reply then.
Thank you, Your Honor, and
But before you reply, Mr. Wickenheiser, Judge Gay, Judge Addison, do you have any questions for the plaintiff?
Only thing I'm gonna verify again, and I'm not at all trying to pick on you and your internet service. It could be mine because I'm on the county's internet provider and providing service. 834 Southwest 3rd, 696, 2016, the Snyder Sixth Circuit case.
Yes, 834 F3D 696.
Thank you.
Snyder.
Judge Gay?
No questions.
All right, now, Mr. Wickenheiser, I'm going to give you a chance to reply.
Yes, sir. Thank you. And I'm gonna just very briefly just really I would just like to address the issue of section 207 again. I read through it briefly and was thinking about it during plaintiff's response. I would just like to, I think maybe reiterate that I think that as far as section 207 creates some avenue for an offender to challenge their designation and seek removal from the registry. I think that as far as, and I know there's a bit of confusion here because we weren't particularly clear about whether this was a 12026 or a 12021, which I apologize for. What I would say is I think that would create some form of standing or connection to Director Rausch's role as it relates to removal. But I don't necessarily think it creates any connection to his ability to enforce the actual geographic restrictions or the requirement to register because, and I think the best way the way I was kind of thinking about it was, what would the relief really look like? Because unless the relief is, well, under, we're going to order you under section 207 to remove him from the registry, that would, I think, be difficult because I think it would probably be contrary to state law. But also it's not really the relief he's asking for, which is I should be able to go into these geographic restrictions and just not have that geographic restriction placed against me. The actual allegations in the complaint are, I don't want the geographic restrictions or the importing or the in-person reporting requirements against me. Well, those restrictions are put in place by other actors. So even though there's this removal portion, that removal portion would, I think, create liability insofar as Director Rausch did not incorrectly denied a removal, which would create, of course, a UAPA action, which plaintiff could have brought but didn't. Instead, he challenged the act itself, and that act itself, as to the geographic restrictions, is enforced by local law enforcement. And so I think it's a quite difficult question. I was kind of working through my way through it a little bit, and so I appreciate getting the opportunity to reply there.
Well, have you looked at these cases that he's made reference to, these federal court cases that what he says address the issue of whether Chief Rausch is a proper party and seem to weigh in on the side that he is? Have you looked at those?
Yes, sir. I have. I think that there's a bit of a split. So the Million case that plaintiff has referenced, I was on that case. That case has actually been non-suited for different reasons, totally unrelated to the merits of the claim. And I think he's right. There's a bit of a split, quite frankly. Some courts have and some plaintiffs have kicked Director Rausch entirely, and they've just brought in local law enforcement. That's been kind of the trend. Some courts leave Director Rausch in, and they say the Sixth Circuit was talking about the geographic restrictions, that he doesn't enforce those, but maybe there are other things that he does. I think that there's a bit of a split. So I wouldn't presume to tell the court how to read those opinions, because there's quite a lot of them, and they frequently disagree with each other, quite frankly. But insofar as this specific complaint has alleged the geographic restrictions issue, I think courts pretty universally, because that's the issue the Sixth Circuit was specifically addressing, at least on that particular provision within the registry, they have said that he does not enforce.
Well, I mean, we're bound. I mean, our ball field is the four corners of his complaint right now.
Yes, sir.
So if that's all he's pled, that's all he's pled. So,
yes, sir.
All right. Does anyone have any further questions?
I do not.
Not from Judge Gay.
I do not.
Okay. Mr. Packinger, obviously there's three of us here, and as you can tell, there are three diffuse, maybe not differing opinions, but we all have something that we're looking for, something else we're looking for, I think. I know that we all want to look over these cases that you've given us reference to. And of course, the state has just now, a few minutes ago, said that, the case that they're relying on deals specifically with the issues that we're talking about here with regard to removal of people from, not removal, but just as the qualifications of and Judge Rouse's duties or abilities under that part of the statute. So if we're going to review the case law that we have, and perhaps if the state would like to back up some of the things they just said with a bench brief or some sort of memorandum that could be shared between us all with regard to these other cases he's referred to, and somehow distinguish them, it would be beneficial. I'm not going to say we can't rule today, is what I'm saying, obviously.
And Chancellor, I'd like to back that up with the state. I'd like a little bit more fleshing out with Memphis versus Hargett. I'd like a little bit more fleshing out 40-39-207. And also, I agree with Chancellor about maybe responding to some of the cases that the plaintiff has mentioned. I think that would be very helpful to us.
Mr. Wickenheiser, how long do you think that would take?
I really don't, I'm not exactly sure. I don't think it should take too long. Probably a few weeks, I would think, just because when I write something, it's got to get approved by other folks, quite frankly, is the reason why. I wish I could just submit it. But
That's the problem.
Is 30 days enough?
yes, sir.
Then we'll give 30 days from today's date. We'll have an order prepared in that regard.
May I circle back to the issues that you all raised, and that I am in absolute agreement with both of my esteemed colleagues as it relates to the standing issue Judge Gay raises and the additional statute that we need to be looking at. I believe is section 207A1 and on. And I would like an opportunity to review not only City of Memphis versus Hargett, but the case law that Mr. Pachinger has referenced. So I'm happy to be flexible with my schedule, but I just wanted to show for the record that I am in agreement with the good chancellor and the good judge.
All right, thank you very much. Are there any other matters that need to be taken up before we adjourn?
Just for my clarity, Your Honors, the case law that I should be responding to, that Mr. Pachinger has referenced, I have Million, Doe, and Snyder. Is there anything else that I'm missing?
I have Million, John Doe's 1 through 9, and Snyder, and the remand from Million.
And Judge Gay also asked you to look into that Memphis v. Hargett issue with regard
Yes.
to the causal connection there.
Yes, sir.
Anything further?
Your Honor, I just want to point out the fact that, but for the classification system classifying me as violent, I'm past the 10-year period that would have allowed me to apply and be removed from the registry. It's that violent classification that's really doing it to me. It's just not right. I mean, it just isn't right at all.
I don't think that that's
again.
I don't know that that's within the scope of what we've been talking about today, though.
Okay. Yeah. If I can point out one more thing, in the rules itself and the definitions of a violent sexual offender, it says that it only applies if you're convicted on or after July 1st, 2004. So, and I was convicted long before 2004. So there's that too.
Well, like I said, we're here on a Rule 12 motion. It deals with, and I made note of it to the state. The playing field we're on is the four corners of your complaint. And that's all we can deal with right now.
Okay.
All right. All right, then the court's gonna call this matter adjourned and thank each and every one of you for your time and participation. And we'll be dealing with each other in the future. Thank you very much.
Thank you. Please have a great rest of your day.
All right.
Thank you. Same from Judge Gay.
Thank you, Your Honors.
Thank you, Your Honors.